Hi there, good afternoon, and welcome to part three of our Energy, Telecoms and Infrastructure webinar series. Today we will be talking about different forms of licenses, and I will be presenting myself. I'm Nat Cartwright. I head up our Energy, Telecoms and Infrastructure team. I'm a senior solicitor at Devonshires, and I'll also be with Grant Durante today, who is another senior solicitor in our team here.
Hi, Ron.
Just some general housekeeping. Slides will be sent to you all afterwards by email, so don't worry about that. Please also be aware that there is a live Q&A session, so you will be able to ask questions, and these will appear on my screen. And so if there are any that we can pick up and deal with at the end, then we will do that. And a short feedback survey link will appear after the webinar. So if you could kindly fill out a survey as well, that would be very helpful for us. I'm going to pass over to Grant now, who's going to introduce himself and just kick off with the agenda for today.
Sure. Hi, runners. Yes, my name's Grant. I'm a solicitor in our real estate team. Been with the firm coming up to 5 years now, and do quite a wide range of real estate matters, part of which includes licenses. So just to quickly run through what we're going to cover today, we'll start off with just a general introduction to licenses, some of the very basic legal principles. We'll move on to some specific development-related licenses to start with. So we'll talk about access, entry, and a couple of sort of specific development-related matters. We'll move on to then personal licenses, which, although similar from a sort of a legal perspective, are used in different sort of practical circumstances, and then finish with a couple of sort of more sort of nuanced, specific types of licenses at the end, particularly with either statutory authorities or for a decant scenario. It's probably worth saying at the outset that there's often an overlap between different types of licenses. So even when we're talking about specifics, it's quite common and certainly plausible to have one license that will actually deal with, for example, both scaffolding and machinery or access, and some of these facets will overlap. So first of all, some general principles. I'll just talk briefly about legal rights. Really, for the purpose of this webinar, we're assuming that we can't rely on these, but it's worth just touching on them very briefly, just because at the very, very start, these are things that that we would consider. Just for the rest of this webinar, we'll assume that none of these have worked. But it's plausible if you've got a title that you have specific rights to do things on neighbouring land, which are expressed, which have been expressly granted as part of a previous transfer or just part of a previous deal. So we would obviously check those at the outset. There's a couple of mechanisms by which you can have implied legal rights. So even though they're not specifically registered on a title, there's a thing called Section 62, which implies certain rights which are necessary for the use of the land into transfers, even if they're not written expressly. If you have, for example, a landlocked piece of land, you can acquire what's called an easement of necessity, where, for example, access is totally necessary to cross land if you otherwise, the land doesn't, for example, abut a public highway. And similarly, in transfers of parts, where you have one freehold title, if it's split into two, there are legal mechanisms by which implied rights can be implied into those transfers, even if not written expressly. The other thing just to touch on, which does come up in these scenarios quite a bit, is called the Access to Neighbouring Land Act. This is essentially a way to go to court if there is no other option to try and secure an order from the court to allow you access to a piece of neighbouring land where it is reasonably necessary for the preservation of the whole or any part of your land, effectively. And the work you want to do can't be carried out or be substantially more difficult without entry on the neighbouring land. On the face of it, that might sound quite helpful, but a couple of things to say on that is that you don't get any rights until you've actually secured an order. So you can't rely on that. You'd have to go and persuade a judge to grant you an order. The threshold is kind of high for preservation, for example. It's arguable that's not the same as improvement or upgrading, that kind of thing. So it can be expensive, can be time consuming. You're almost certainly not going to be popular with your neighbours. So this is, although it's an option, it's generally more of a last resort than something you'd want to rely on in the first instance. I think for the rest of this webinar, we're going to assume that none of those options are viable, and instead we're going to look at different types of licenses that you may use to do whatever you'd like to do. Next slide, please, Matt. So what is a license? It's effectively a contract which allows one party or whoever is authorised by that party to do something on another party's land. So it's essentially a private agreement between two landowners is the most common scenario. A license doesn't grant any kind of legal interest in land. You can get rights by deed, you can get rights included in a transfer, which would bind the land and therefore carry on. So if one party sold their land, the person they sell to gets the benefits of those rights. That isn't the case with a license. A license is personal to the parties that have entered into the license. So it just sticks with those parties, and in the event of a transfer, it doesn't carry on. Licenses can take many forms. I mean, often they will on the face of them look like a contract. They will look like the kind of documents that you would often see, but there isn't. The formalities for execution are similar to that of a contract, but licenses often look different depending on who the parties are, what it is that's being permitted, whether it's actually just essentially permission rather than something a bit more technical. They can look quite informal, they can look very formal. There's many different ways of producing a license, and it's worth noting that there's no automatic right to get a license even if you need one. It's effectively a deal between two neighbouring parties, and if you need to put scaffolding on your neighbour's land, assuming that going to court isn't going to work, you don't have a right to do that automatically just because it would be convenient. A license is effectively a deal. So while they can be helpful, it's important if in the context of a development, certainly if you think you're going to need one, to suss out whether or not the neighbour is likely to be open to granting one at the earliest possible stage. And next slide, please, now. And finally, very quickly, some specific things that you might want to do, which would be in the context of development, which would be catered for by a licence. You may want to alter your building, inspect some neighbouring land, install equipment, repair the building that you've got or maintain it, even improving, upgrading. You may want to be storing either items on another piece of land. For example, if you've got a garage or even just a development site, you may be looking to erect a site office, for example, or just generally access through the right of way or covered by a licence. And with that, I'll hand over to Nat to talk further about licences.
So these can also be very useful legal instruments, ancillary to an underlying contract, whether that's a development agreement or an agreement for sale. Essentially, it will grant a temporary right of access for a specific purpose, and there will be standard conditions of entry attached to the license, which we'll cover a bit later on. They're very useful, for example, where you have a conditional land sale agreement and you, as the prospective purchaser of the land, isn't quite aware at this stage of what sort of environmental problems you might encounter, whether there's contamination or things like that. So it's a good opportunity to get onto the land at the point of exchange and have a condition in your land sale agreement whereby you won't complete on the transfer unless the ground condition is satisfied, and that might be, you know, satisfactory outcome of surveys and searches in relation to the technical DD, due diligence, that you'll be doing at that site. So they can be very useful for that purpose. And in that instance, we'd usually see a sort of isolated, separate license appended to the contract to be entered into upon the point of exchange. Similarly, you may see them in golden brick development agreements, not necessarily as an isolated license, but as a provision, certainly itself within the document. This might be necessary because if you're taking the land at golden brick stage, then the developer will need to come onto the land that has been transferred to you at golden brick in order for them to complete the works between golden brick and practical completion. So because you would have acquired the land interest, the developer will then need a right in order for them to carry out those works. So it's quite common to see, once you've had the land acquired, transferred over to you, you then grant a license back to the developer to complete those works. And it may be also necessary for you as the potential buyer to also have a license provision in there in the event of insolvency by the developer. The reason being that if you've only acquired a certain parcel of a wider site, but you need to sort of build out the rest of the site where you have other units, then you're not going to have a legal interest in the remainder of the site. You're only going to have a legal interest in the bit that you've acquired. And so therefore you will need a right, if that's written into the contract, to build out the rest of the development. So they can be very useful tools as sort of ancillary documents to contracts as well. So just looking at some sort of standard conditions of entry, these are some usual things we would expect to see in licenses. So they'll often be a consideration. As Grant said, these are, you know, often a deal between two people. So there's a bit of negotiation involved, and you won't necessarily be able to get that party to agree unless you raise your price to a certain figure. So, you know, there will be people who hold out for certain sums, I suppose. There will also be a license period usually in there. There could also be hours in which you can operate and exercise your rights. So that's important to be aware of. And you'll often be required to obtain all necessary and requisite consents, things like planning permissions, any sort of local authority approvals, certificates, and things like that. You'll usually be under an obligation to carry out the works with diligence, care, and skill, and also causing as little nuisance and disturbance and damage to the property. And you'll usually also be under an obligation to make good any damage caused. This would be to the licensor's reasonable satisfaction and often at the licensee's sole cost. That's what we would expect. There will often be an indemnity provision in there. Obviously, in case anything goes wrong, the person who's granting you that right over their land will obviously want to make sure that they can recover any sums against any claims or costs or expenses which arise from the grant of the license and the exercise of those rights, or any breach of covenants which may arise. And so in line with that indemnity, there'll often be a requirement as well to take out insurance. Professional indemnity and third-party liability insurance is common in licenses, and we would usually expect the sort of level indemnity in the indemnity that you're providing on the license to match the indemnity cap on the policy. So let's just move on to the next slide. So now we're going to look at a couple of sort of construction development related licenses. Grant is going to talk about scaffolding licenses first.
Sure. So the most common scenario here is where you need to erect scaffolding around a building, and if, for example, the building is built up to the footprint of your boundary, where you put the scaffolding, around the outside of the building, might actually overlap into a neighbouring piece of land. So you would need a license to put the scaffolding onto their land, either for to do work to an existing building. It's quite common in cladding remediation cases, for example, where works are being done to the exterior of a building. If a block of flats, for example, like I say, if the footprint's up to the boundary, you'd need to put scaffolding around it, which would overlap. But also, it may be necessary if you're building a building up, which sits up to the boundary. You may still need to put scaffolding onto a neighbouring piece of land to enable you to then build on the land that you own. So a couple of general considerations specific to scaffolding. Next slide, please, Nat. First of all, is your neighbour agreeable? Have we agreed terms, which we would expect to be along the lines that Nat has just outlined. For example, a compensation to be payable, some kind of premium or inducement. Timing, how long you can keep it there. It's worth considering at the very outset whether the access to neighbouring land is absolutely necessary from a technical perspective. It might be that it's more convenient, but it might be that it's not absolutely essential. And it's worth weighing up the cost of, for example, the compensation that your neighbour is asking for versus the cost of altering the technical methodology, if that's possible, even if your slightly more expensive way of constructing scaffolding might still be overall more beneficial or cheaper than paying the compensation. So it's worth considering that right from the outset. Just on timing, it's worth giving some thought to whether you would have a right to extend the licence. It's not uncommon to have a licence of an initial period with a right to extend if certain things haven't happened. For example, if work hasn't completed, would be the most obvious. But equally, it's quite common to see a long stop date because from the point of view of the person who's giving the licence, they will want to know that at some point the scaffolding is going to come down, whatever happens. Otherwise, they run the risk of having the scaffolding up there for years and years, and they'll want to know there's going to be a point at which it comes to an end. It's also not a given that you'll have a right to extend. We've seen it before where the parties have just agreed, just a specific period, and that with the long stop date at the end of that period. And in considering and agreeing that timescale, you'll need to be confident that you've got enough time to access the land, put the scaffolding up, do whatever you need to do with the scaffolding, and take it down and remove it all within the time period which has been agreed. If you're not confident in that, then we would suggest certainly opening discussions about a right to extend built into the licence. Once the licence has been granted, it's a lot more difficult to agree an extension because you don't have a right. You're essentially doing a new deal, and if you run out of time, then you've actually got no right to be on that neighbouring land, and would be trespassing if you kept the scaffolding up. And I suppose your risk is you then end up taking scaffolding down when you've only actually done half the works, which is probably not going to be any good. Is there a right to wrap the scaffolding, for example, for sound insulation or for privacy reasons? We've seen that asked for, and then we've seen specific specifications required for the wrapping or other technical specifications. So you're only allowed to put scaffolding up, for example, of a certain size with certain wrapping around it. And just a final point on scaffolding, which is specific to blocks of flats. If you are the freeholder, it's worth giving some consideration to whether or not you're if the building is occupied, whether you have the right to put scaffolding up around your building in such a way that actually interferes with any of the leases you might have granted. Often we see leases which expressly reserve a right for the landlord to erect scaffolding around the building. It may also fall into the category of repairs or improvements that the landlord is allowed to do without tenant consent. From the tenant point of view, they sometimes have a right to light and air under their lease. If you put scaffolding up and it blocks light, then a tenant can object on that basis. So we would ordinarily look at whether or not the landlord has the right to obstruct light or air going into the flat. And it may be that even if you have the right to erect scaffolding and to obstruct light and so on and so forth, you still have to give notice to your tenants, and that may be reasonable notice. It may be a specific time period, it may be a specific method. So in that wider context of scaffolding around an existing building, we would also look at the position of the current occupying tenants. Now over to you for overselling.
Yeah, so an oversailing license, these will often be required where you need a crane on site as part of your development, and if any part of the crane, usually there's the part that extends out is known as the jib, and that is the bit which will usually require an oversailing license if it is apparent from the sort of crane the crane layout, which is often sort of prepared by the architects in their drawings at the early stages. They can get a good idea of what sort of third-party land encroachment there's going to be. And so if there is going to be any third-party land encroachment, then that's when an oversailing license will be required. It may be one owner, it may be numerous landowners, and so it will be a case of getting your lawyers to do the usual sort of title due diligence, going on the land registry and trying to ascertain how many properties are affected, who is the current registered proprietor. But then you may also need to combine that with a bit of good old-fashioned door knocking, because the registered proprietor on the land registry's website may not necessarily tell you who's actually occupying the property at the moment. So there will it is of course common to pay a fee to the injured parties, and as I said before, that fee is a negotiable fee, and there's nothing which could possibly oblige any of them to sign up to the oversailing license. So it will just be a case of making them an offer that they can't refuse a lot of the time, unless they are just very sort of obliging citizens who are also keen to see your development go ahead, and so it may be a bit easier. Where the third-party land, it's just worth noting that where the third-party land is adopted highways, the local highways authority will usually have its own standard template. You'll need to engage with them pursuant to section 169 of the Highways Act, which relates to sort of anything oversailing highways, or which could be a crane, but it could also be scaffolding. So the same thing applies with scaffolding licenses. There may also be a specific template which the local highways authority will want to use. In the same way as any license, these licenses will also be subject to the standard conditions of entry that we've previously talked about. It's probably worth just considering whether there's actually going to be any load in terms of development materials which are going to be carried over the third-party land, because obviously if there is, and it's significant, then there's a greater risk therefore attached to the license from the sort of adjoining property's point of view. That may mean that you need to take out more insurance and provide a higher indemnity. It will probably also mean that you need to provide prepare a more comprehensive risk assessment method statement for the licensor's approval. So that's just also worth bearing in mind. And I'll pass back to Grant to talk about machinery licenses.
Sure. Just one final thought on oversailing licenses. Just to flesh out some of the legal principles behind it. Even if it's just a flat piece of land with nothing on it, your neighbouring freeholder will own right the way down into the court and right the way up into the airspace as well. So even though you might actually not be, you're not practically touching any of their land or anything that's on it, they still own that airspace, even though the crane could sort of dangle freely. That's why we still need their consent, even though you're not stepping onto their land as such. Machinery licenses are broadly similar, but we're looking at machinery which is not necessarily of the scale of a crane. We're more thinking the mini diggers which are sort of operated at ground level. dumpers and things which can bring in materials and remove soil, the sort of things which wouldn't oversell a neighbouring property, but you may need to drive over neighbouring property, neighbouring land to access your land, or to actually operate from the other side of your boundary in order to do work to your own land. In practical terms, this is more likely to be pertinent on an infill development, which is where you're developing within an area which is already developed. The opposite would be if you've just got an open field which is going to be built on with nothing around it. So you're often in more residential areas, you're in areas which are occupied by sort of multiple people, and you're actually building your development sort of within the middle of all of that. So neighbours and neighbouring landowners are much more likely to be concerned about what it is that you're doing and the impact it's going to have on their land and their use and enjoyment, especially if it's their home. Noise may be, for example, a particular issue. So we'll just talk through a couple of specific considerations in that context. Now, next slide, please.
Yep.
Here you're likely to need to be quite detailed on the specification of your machinery, the size and the type. We have seen it before where sort of literally either pictures or sort of model numbers of certain diggers are included in the license, and even the number of them that you're allowed to use. So you may only be allowed to use one at any one time. You may be allowed to use two at any one time. The hours in which you're permitted to operate them are also likely to be specified, and whether or not you can or can't use them on weekends or public holidays, for example, or if I know the week before and the week after Christmas there might be a hiatus actually built into the license. Any noise mitigation measures that you might be obliged to carry out, any sort of screening, or I guess this also comes back into hours of operation, or even a certain level of noise that you're permitted to make. I mean, just simply measured in decibels. There may be an upper limit on what you're permitted to do, so you need to be comfortable from a technical perspective that that's not going to be a problem for you. Timescales in which you're allowed to bring machinery across the neighbouring land, whether or not it's only for a certain number of days within the wider development period, or whether you're allowed to bring machinery at will for the next 6 months, for example, or the next year, or only for 30 days within the next 6 months, and whether, if it's the latter, whether or not you have to nominate those days or whether you can choose them, all matters which would be negotiated. If you're bringing machinery over grass, for example, you may need to lay some kind of temporary tracks, to temporary to the hard surface, so as not to damage the land. And similarly, you're likely to have an obligation to make good any damage to the land that you make. So I'm going to move on now to personal licenses. So these are not necessarily development specific. The legal mechanism is still the same. It's still an agreement between two parties to do something that one party otherwise doesn't have the right to do. But for this next section, we're much more likely to be talking about either neighbours or a landlord and tenant relationship, rather than sort of developer and that kind of relationship. For example, you may have a right to use a parking space. If you don't own that parking space, you could get a temporary license to use it, either for a certain period, for certain hours within a certain period, or certain days. Maybe you may have a license to store materials in, for example, a neighbouring garage. I mean, these are particularly pertinent to blocks of flats. For example, if there are communal garages and certain units have got the right to use them, one of them isn't using it, it may grant a license to a neighbour for a fee to allow them to use either their garage or their parking space. Similarly, a landlord could grant a license to keep a pet at a property if the lease doesn't allow pets, or the lease, for example, says that the pets can only be there if the landlord has given specific consent. Then that consent could be in form of license. Similarly, in terms of leases, leases often prohibit alterations, either entirely or without the landlord's approval, and if that is the case, then that approval or permission can often come in the form of a license. And just on leases specifically, it's worth noting that even if a lease prohibits it, that doesn't stop a landlord giving a license to do it and waiving essentially that prohibition. But there's no obligation or guarantee that the landlord will do. But if it so wishes, it can grant a license. Next slide, please, Matt.
Yeah.
It's worth noting that these are not registrable. Licenses don't grant an interest in land, so you wouldn't be able to register them at the land registry. In practical terms, that can be an advantage, but it does mean that if you're buying a property, it won't be apparent from title documents that a license is in place. Which makes it doubly important that a physical inspection is carried out of the property to be able to see if there is anything obvious on the ground that would suggest that some certain right is being exercised. It can, but the flip side of that is it can be kept confidential, and it's often a term of a license, particularly in the context of residential property where a landlord is granting a license to do something which would otherwise be in breach of a lease, for example, keeping a pet. It might be that the landlord doesn't want their neighbours to know that they've granted this license, and so there'll be some kind of confidentiality obligation. They are rarely assignable. Technically, it's possible, but it is highly unusual, and I'd say if you're granting a license, you wouldn't want it to be assignable, just because of its very nature. If it's a right to do something which is temporary and personal, you wouldn't want that person to then be able to assign their license to somebody else. And similarly, on that theme, because it doesn't bind the land, it means it extinguishes on a sale, and that person would no longer have the right to do whatever it is that they've been doing. And quite often licenses can be revoked, and there might be conditions which, if a landlord, using the pet example again, if the pet is causing noise, the landlord's allowed to revoke it and unilaterally, and that's that. So again, that can be advantageous in the context of a private deal. I think back over to you now.
Yeah, so I sort of briefly touched upon this before, but where the adjoining or third-party land is adopted highways, you will need to enter into a license with the local highways authority, and so here there are two examples here. One we've sort of already kind of discussed, which is with the crane oversailing. Be aware that each local authority will probably have its own templates. It'll also set its own fee for a scaffolding license or an oversailing license, and that'll be in connection with a specific time frame. So if you need longer than that time frame, they would just increase the fee, but it's usually set out in quite a clear sort of table structure on their website. So if you go on any local authority website, you can usually find a link to their sort of their highways template licenses. Another example is where part of a building or a structure pertinent to a building on new development, for example, where such as a balcony which protrudes over the adopted highways below, and as Grant said before, it's not necessarily a sort of physical intrusion, even if it's in just the airspace above. That is still considered a third-party encroachment. So in that instance, you'd be required to enter into a section 177 license with the local highways authority, and again, similarly, these can be found on the on their website. Just be hesitant not to pay too much attention to section or statutory references to legislation on these local authority websites, because they're often muddled and they usually cite the wrong statutory provision. Again, there's another example is a streetworks license. These are very common with utility or statutory undertakers who need to sort of dig under adopted highways, dig a tunnel to get to apparatus lying beneath the adopted highways. And once again, these are again in a very standard template format and will be provided by the local authority, assuming that you pay the fee and fill out their application online. So it's quite a straightforward process with these highways licenses, but it's important to engage with them early on, because they can be slow in responding, and there are a few sort of application forms to go through. And then there will also be individual licenses, which will apply just to a very specific protected species. So some forms, so there's a bat mitigation license, for example, if you're planning on redeveloping an area where there are currently protected species of bats, and if that's going to disturb their natural habitat, then you'll need to enter into a license, which will have a whole list of provisions setting out how you can mitigate any interference or disturbance. Similarly, if you want to upset a badger set or something like that, or if there are mice or voles or anything sort of, that you'd find in sort of natural wildlife areas. And if you are going to upset any specific species, then you would need that sort of license. There are then organizational licenses which apply where you have sort of routine disturbance and your organization will out of habit naturally make a disturbance to the wildlife, but just out of what it does as a course of business, and so that sort of license will work on a more sort of rolling basis rather than being in place for one specific purpose. I'm now going to pass back to Grant to talk about decant licenses.
Sure. Last one for me is decant licenses. So just to set the scene here, this is if you own the freehold of a building, likely a block of flats, and you need to do work to the block of flats, which means that you're going to need vacant possession of either all or part of people's flats. But you have leaseholders in there who own their flats. You would need what's known as a decant license, and this is in the context of essentially emptying the building and rehousing either temporarily or permanently the occupants. It would both need to allow you access and also detail the work that you're going to be carrying out. In the times I've come across decant licenses, it's often quite involved and quite heavy duty sort of structural work or fire remediation work, which cannot be done from the exterior of the building. It is also quite common just for general internal structural works or upgrade works. Next slide, please, Nat, for some considerations. First of all, compensation, whether it's going to be payable per week, per month, how long it's going to be payable for, whether it's just going to be a flat sort of fixed sum, whether, given that these are people's flats, you will need to reinstate it to its existing condition, and how that is documented. Often, a license will say that before work of this nature can be carried out, a landlord and the occupier will carry out a condition survey, take photos, and actually document them and agree them before the work is carried out, and that then sets the standard to which the landlord has to reinstate or replace, for example, any furniture which stays in the building, just to an equivalent quality or standard just to that which it was at the start. Some thought will need to be given to what happens to personal possessions which might be in the flat, and who covers the cost of the storage. Often it will be the landlord, and whether or not that is going to be paid essentially almost reimbursing off of receipts, for example, or whether it is just a flat payment which is allowed for storage costs, and then the tenant essentially takes the risk that if that's not enough, then they'll make up the difference, and if they're able to get it cheaper, then they keep the difference. So that mechanism will need to be thought through and agreed with each tenants. Often in these scenarios, you have quite a lot of flats. So ideally, you want the license to be in one form, just for simplicity of managing the project, and because that way you only then need to familiarize yourself with one type of license, rather than each license having slight nuances, which you then need to factor in. Similarly with cost, if one neighbour finds out that the neighbour is being paid more than them, they're unlikely to be particularly impressed, and if it's before the license is granted, are unlikely to sign it. So it's easiest to have the licenses in a common form. Practical difficulty with that is often tenants will have different comments on licenses, and what they are willing to sign up to. So agreeing position with a large number of people can be logistically problematic, but is also necessary for this type of project. Long dates, it's worth giving some thought to whether or not work will be done on a phased basis, whether or not you need access to the whole building at any one time, or whether it's, for example, floor by floor, and if so, whether the decant will happen on a phased basis, whether or not how much notice you need to give each flat that they need to vacate their property, and what's going to happen in terms of finding their alternative accommodation, whether the landlord is able to do that or whether they're doing it themselves. If people are going to be moving into rented accommodation, they'll often need notice to go and sort that. And finally, again, it can be logistically challenging just because of the numbers of moving parts, but it's important from a practical point of view just to try and keep it as consistent as possible across the project. I think that's all we had in terms of slides. So if anyone has any questions, we'll just take a quick look at the Q&A.
I think we've probably got one. We've got time to pick up one question. Ellie, thanks to your question, you've asked what are the options if a neighbouring landowner is refusing access despite an express right in the transfer. I think firstly you'd need to consider what sort of express right has been granted here. Is it conditional or is it unconditional? So is it a right but still requiring the consent of this neighbouring landowner, or is it a purely unconditional right of way or whatever right it is? There isn't enough information in the question, unfortunately. But if it is completely unconditional and you have that express right in there, then you should just draw your neighbour's attention to that fact, and if you have to instruct a lawyer for them to basically sort of make that point to the neighbour and say, well, if you don't allow you to exercise that right, then they could potentially take you to court. So I don't know if you have anything to add to that, Grant, but that's.
No, I was going to answer along similar lines. Ultimately, if it's an unconditional right, then you should be sort of cracking on. You'd probably be well advised to draw their attention to what you're doing and why. Because here is the right, here's the document it's in. But if they're just being completely obstructive, but without a legal basis, then it probably is like to possibly go litigious. You'd like to think that if you're on pretty solid ground, then they'd either back down or some kind of agreement could be reached. But ultimately, the an express right is an express right, and whoever acquired that land subject to that express right either would have known about it, or will probably be speaking to their acquisition solicitor as to why it wasn't picked up at the time that they bought it.
Yeah. Okay, thanks, Grant. Okay, so I think we'll probably wrap it up there. So I just want to thank everyone for joining today's webinar session. We'll be sending around an update on what the next session, what the next topic of this series will be on. In total, there will be about 12 topics, so it is going to be a series over the next sort of course of the year. So please be sure to tune in to part 4, which will probably be in about a month's time.
Brilliant. Thanks, everyone.